Good morning. Are you Warren Mills?
Good morning, yes, ma'am.
And Mr. Mills, in cause number 25 DCCR 0082, you're charged with the second-degree felony offense of assault on a peace officer. That's from November 19th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yeah, I understand that part, yes.
Okay, and I have a plea bargain here on the computer that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that and have your case go to trial and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plea.
Yes, ma'am.
You understand all of that?
I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am. Yes, Your Honor, ma'am. I wanted to reject it, and then I wanted to see, at that point in time, because I was, I was incompetent at one point.
Okay.
I was out of my mind, which I have a history of it before.
Okay.
Mental health.
Okay.
But I just wanted to say on docket for everybody that in my mind, in my heart, my mind was so I would never hit office.
Well, so
Just the situation that I'm in.
The allegations allege alcohol and drugs.
and is there a video?
That's what I was asking. I wanted to.
Hold on.
Oh, yes, ma'am.
I didn't see a video on Discovery. There may be, but I don't.
I have
didn't see one.
a thumb drive in my file, Your Honor.
Let me do this. So before we move your case to the trial docket, I'm going to let Mr. Parker have some time to get a copy of that video. And then he can come show it to you. You may not remember everything, but maybe that video will help you understand what happened and then see where we get from there, okay?
Thank you.
If you still want to go to trial after you see the video,
Excuse me, ma'am, Your Honor, I really don't want to go to trial.
well, that's what,
It's kind of,
I want you to see everything. I'll give them some time to get that taken care of, and then when you come back, we'll see what you want to do, whether it's a plea or a trial, okay?
okay, thank you.
All right, you can go back with the
Can I
bailiff.
ask you one more question, you mind?
Yes, sir.
In a situation.
Right from the start, the defense isn't denying the violations, they're asking the judge for mercy. But in probation cases, judges aren't just listening for apologies. They're looking for proof that someone has actually changed. Will this be enough, or has that opportunity already passed?
Of that situation, did probation ever come across the table?
That's between your lawyer and the district
Oh, okay.
attorney's attorney. It's whether or not they offer
I
it.
wouldn't, okay, thank you.
Okay. I'm just going to delete the rejection if
Okay.
it's we'll do it again later if that's the case.
Okay.
All right. Good morning, sir.
Good morning.
Are you Samuel Jones?
Yes,
And Mr. Jones, in cause number 25 DCCR 0043, you're charged with the second-degree felony offense of burglary of a habitation. That is from November 21st of 2024. Your indictment alleges that you were previously convicted of fraudulent use or possession of identifying information, a second-degree felony, October 20th of 2021. And after that was final, you were convicted of theft of mail, a third-degree felony, December 12th of 2022. What that means is that if you go to trial in this case and you're found guilty, you would be considered a habitual offender, which means your minimum punishment if you're found guilty and those prior offenses are true is 25 years in prison up to 99 years or life. Do you understand?
Mm-hmm.
And I need you to answer yes or no, please.
Yes, yes, Your Honor.
Thank you. And I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that and have a jury decide if you're guilty and what your punishment would be if they find you guilty. I just want to make sure you understand what the possible... Okay, I just want to let me finish. I want to make sure you understand your consequences possibly and what your options are.
Mm-hmm.
And you want to reject that offer and have both cases. And so you also have, and let me go through this too just for the record, in cause number 25 DCCR 0232, you're charged with burglary of a building, a state jail felony. And that is from January 5th of 2025. I'm assuming those same prior offenses are alleged in that one, which means in that case, if you're found guilty and those priors are true, the range of punishment in that case would be between 2 years and up to 20 years. Do you understand?
Yes,
Okay. And you want to reject that offer and have your case set for trial?
yes.
All right.
And I like to indict everybody who have witness. I like to indict everybody.
Now the hearing takes a critical turn. The judge begins digging into every new offense and every pending case. This isn't curiosity, it's how the court determines whether probation has become a complete failure. Every answer matters from this point forward.
calls this case, sign the case.
Okay, so-
Fingerprints, evidence and everything. I want everything to be,
He's
everybody
complained,
indicted.
he's complained about some charges that other counties have explained that
Yeah,
doesn't have anything to do with
I'm
here.
saying-
So,
He
so
wants
here,
everybody here, and I told him everybody will have to be here at trial whenever.
yeah, I mean, whatever the
Okay,
district,
well, I
listen,
want to let you know, I'm 17 code, my code is 774 is my badge number. 477, Barras, Bear County, Patrol Detention Center.
okay,
Private detective and everything,
okay.
private investigator.
All right. So here's what we're going to do before we move any further with this is I'm going to, Mr. Jones, I'm going to have someone talk to you to make sure you're competent to stand trial, get all your history, make sure we're all good before we go to trial.
Yeah.
When they visit with you at the jail, either in person or on the computer, you need to make sure and cooperate with them, and then we can move your case forward, okay?
Yeah, it'll be fine.
All right, go back with the bailiff, please. Everybody keeps, y'all just wait, I'm gonna get everybody. All right, are you Evan Bowden? Mr. Bowden, you're charged in each of your cases with evading arrest or detention with the use of a vehicle, and what is the announcement?
Your Honor, this is the case where he also has a pending motion to revoke probation out of Chambers County. I've been trying to work something out with him. The prosecutor handling that case is Eric Carcerano, who's currently in Austin for trying a legislative issue right now. I call it.
This is,
I know, but if I plea him out to this, Your Honor, that's automatic revocation over there, and he's gonna get it back. I know it doesn't affect this court, but it does.
I mean, you've
me.
been on the case since June of
Oh,
last year.
I know.
So here's what I'm gonna do, I'm gonna reset it 2 weeks.
Oh, that's fine. It should be fine,
And
yeah.
that is the final reset.
Like I said, there is-
Hold on, it's either going to trial or it's going to get taken care of on that day.
So I'm saying, the offer that the state's made, we want to accept, we like it, it's great. It's just a matter of I don't want to do something here that's going to automatically send them up there.
Well, there's
Once I get
been,
the-
I'm
I
sure
know.
he hasn't been in Austin this whole time.
No,
so-
it's just been since
all
our
right.
last resetting.
All right.
So, yeah.
You can go back with the
But,
bailiff.
yeah, we'll get something done in that amount of time.
Good morning. Are you answering?
Listen carefully, the judge is laying out the entire timeline like a puzzle. Burglary, probation, new offences, missed opportunities, and then disappearing for nearly 2 years. In sentencing, patterns often speak louder than promises, and this pattern isn't helping the defense.
Case
Is it the same
looks like
in each
3 new
case, or was it
cases.
an
Is that
agreement for
correct?
a dismissal?
And what is the announcement?
We are working on a deal to sort of put this all under one
Okay, and did you do
umbrella,
2, please?
And that would
Okay, they're both here?
potentially-
Okay, I'm sorry, I
we
just saw
haven't
one.
finalized it, but would
Mr.
potentially
Flemings, in cause number
involve,
24,
ISF
DCCR
and
2144,
probation.
you're charged with the second-degree felony
But it's
offense
not
of
finalized.
assault
What I
on a
would
peace
ask is maybe a
officer
1 or 2
from
week
September
reset. We don't
11th
want
of
a bunch of time.
2024.
As
That
you know,
indictment
Mr. Raymond
alleges
has
that
some
you were
health
previously
issues that,
convicted of possession
we're
of a
sort of
controlled
consistently
substance of
having to
third
address.
degree
The sooner
felony
we get a
September
deal done,
27th of
we want to do it.
2023.
Mr. Coleman and I
And what
need
that
to
means
consult.
is that if you go to trial and you're found guilty and that prior offense is true,
We'll do
the
2
range of
weeks.
punishment would be
You can go back to the bailiff.
between that of a
Good
first
morning.
degree
Are you
felony,
Chad
which is
Holland?
between 5 years
And
and
Mr.
up
Holland's
to
charged
99
with
years or
fraudulent
life in prison.
securing
Do you
of
understand?
documents
or securing execution of documents,
Yes.
Mr. Gertz?
Judge, we have got the paper discovery in this case. We requested a while ago, but you haven't gotten notice
Okay,
of,
and Mr.
but,
LeBlanc, did you go over that with
Mr.
him as well?
Coleman and I have talked about the video discovery, and so we're trying to sort that out here, where that is.
Okay.
Mr. Holland does not intend.
So,
anything to
Mr.
take this to trial.
The state
Absent
has
something
information,
magical
he
on those
says, that you
videos,
have more than one
but,
felony
realistically,
conviction
we
from
want
before.
to work out a deal. but
So
I just
if
need
that's
to
true,
see.
if you have at least 2 that are from different dates, and you are found guilty, that changes this from a first degree up to a habitual offender status, which is a minimum of 25 years in prison,
if you'll
up
just
to
make sure
99
and get
years
with
or
Mr.
life. Do you
Coleman
understand?
soon,
And if there's
and
anything that
in
needs to be
clause number
copied, I'm sure he'll get
24
that to you quickly,
DCCR
and y'all can review it, and we'll get an
2145,
announcement at the,
you're
next
charged
day.
with the state jail felony offense of injury to a child, elderly, or
Good morning, sir. Are you
disabled.
Kenneth Cole?
Excuse me,
And will your
individual
client
from
waive the
September
formal reading
11th
of
of
the
2024.
That
Mr. Coleman,
indictment
cause number
alleges several
20-34802,
prior state jail felony
I have a motion to revoke your
unadjudicated
several.
probation. Shows that you were placed on probation April 4th of 2022 for the offense of burglary of a habitation. And that was a 6-year
9,
deferred probation.
10
Is that
prior
correct?
state jail felony offenses.
It alleges that you violated your probation.
It does not
Count
allege
1
those
alleges
prior
that you
regular felony
failed to report in
offenses,
person to the
but
Beauregard
if
Parish
you have,
probation
again, 2
September,
regular felonies
October,
that are
November, and
sequenced, not on
December
the
of
same
2022.
day,
And is that true or
in
not
that
true?
case, it would make it a
True or not
second-degree
true?
felony offense
Thank
for
you.
punishment purposes, which has a punishment
Count
range
2
between
alleges
2 years and
that
up
you failed to
20
report by
years.
mail
Do you
or online
understand?
to the Jefferson County Probation Department for May through December of 2022, and then January through December of
Okay.
2023,
Okay.
January through December of 2024. Is that true or
Y'all
not
did
true?
it, but you do have the prior.
Count
so it
3
could be.
alleges
Y'all
that you
just
didn't
discuss
immediately.
it.
That line says everything. I can't give you a fourth shot. Probation is designed to help people rebuild their lives, but it's also built on accountability. Once a judge believes repeated chances have been ignored, prison becomes far more likely. Do you agree with the court's decision?
Report
Okay.
to
So,
the
but you
probation
understand
officer,
now,
your
I've
address
admonished
change.
you, and
Is
you
that true or not
understand,
true?
and you know what your history
I'm
is
sorry.
if you have a prior felony.
Count 3
two prior
alleges that you
felonies
did
that
not
aren't
provide
state jail,
verification of
and you're found
performing
guilty,
the
and
service
the
hours
minimum
is
punishment
required.
is
Is that true or
25
not
years.
true?
You understand?
Count 5 alleges
And that's
that
on the
you did
that's
not
on the
provide
assault
verification
case
of
a peace
entering and
officer, and
successfully
the other
completing
range of
the
punishment
battering intervention
in the
and
injury to a
prevention
child would
program.
be
Is that
2 to
true or
20.
not
You
true?
understand?
Count 6 alleges that you failed to surrender
Okay, and so
yourself
I
to
have
law
here on the
enforcement
computer plea
authorities
bargain
in Blair,
rejections that
Nebraska,
you've signed with
as
Mr.
of January
LeBlanc
3rd
that
of
shows that the district
2025. Is that
attorney's
true or
office
not
has
true?
made an offer of 8
Count
years
7
in each
alleges
of
that
those
you were
cases
behind
to
in
run
your court assessed
concurrently,
fees. Is that true or
which
not
means at
true?
the same time.
Did you
You
enter
have
your
every
pleas of
right
true
to
to
reject
counts 1
that,
through
have your
7
case set
freely
for trial.
and
I just want to
voluntarily?
make sure you understand
And
what
because
your
those
possible
counts are all
consequences are if
actually
you go to
true.
trial, what your
I
options are.
have here on the
Do you
computer some
understand all of
documents
that?
that have your signature
And
on
do you
them
want to
that the
reject
state's
that
marked
offer
as
and have your
exhibit number
cases set
1.
for trial?
Before you went
All
over
right, we'll get it
these
set
or
for
signed
trial.
these, did you
Mr.
go over them with Ms.
LeBlanc will
Holmes?
begin preparation
And
for
do you
trial.
fully
You go back
understand
with the
that?
bailiff.
Ms. Bean, in cause
And it
number
looks like the
23,
agreement is
DCCR
for me to
2068
continue you on probation
You're charged
for you
with
to
theft
enter and
of
successfully
property in
complete
an
the
amount
safety
more than
program. Is that
2,500
correct?
with
And I want
previous
to make sure
convictions,
probation's
which is
here,
a
and
third
so
degree
would you just state your
felony,
name for the record?
from April
And you feel like this
6th of
is best,
2023.
considering
The
everything.
indictment alleges you were previously convicted of theft September 4th of 2014,
Once out of
December
safety,
22nd
if I
of
do this,
2015,
where would you be living?
December 6th of 2017, December 7th of
Anything else,
2018,
Mr.
and
Smith?
June 24th of
State tenders
2019.
number 1.
How do you plead to that
It's admitted
charge?
any evidence that Mr.
Are you
Cole's
pleading
not
guilty
competent?
freely and
All right,
voluntarily?
Mr. Cole, you're going to get an
And are
opportunity
you pleading
today
guilty
that you
because you
will
did what
likely
they
not
charged
get
you with?
again. Sounds like you just
And then in cause
went
number
away for a very
23,
long-
DCCR 2069.
One defendant leaves, another steps in. But this case carries even higher stakes. Because of prior felony convictions, the sentencing range has increased dramatically. Sometimes a criminal record can matter just as much as the current charge itself.
Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Bean is not competent?
No, Your Honor.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 23, DCCR 2069, find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions in an amount above $2,500. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that the law gives you the right to receive. In addition to that, I will give you credit for any from the date of indictments in each of these cases, which is from November 29th of 2023. So you will receive credit from November 29th of 2023. Y'all have marked that on here as 624 days. I'm going to assume that y'all did that math correctly. But it's for sure from the date of indictment on each case. Do you understand? And then in cause number 23, DCCR 206, which one did I just do? That I made the finding? Okay. In 23 DCCR, you good? Sorry. 2068, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of theft with prior convictions in an amount above $2,500. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Correction. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive, and also specifically from the date of indictment, which is November 29th of 2023. These two cases will run concurrently, which means together at the same time. I have handed you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right? Good luck to you, ma'am. You can go back with the bailiff.